Thank you. It's a pleasure to be here to speak to you about H.R. 1249, the America Invents Act. Specifically, I'm going to be speaking to you about Section 2 of H.R. 1249, which changes the U.S. system from a first-to-invent system where the inventor has the presumptive right to get the patent, the property right in the invention, to a first-to-file system. Now, one thing I want to quickly clarify for you is that Section 2 titles it not as a first-to-file system, but it calls it a first-inventor-to-file system. And I want to just point out to you that that is purposefully confusing neologism. And it's very revealing that despite the fact that the primary argument for moving to a first-to-file system is harmonization with other countries, no other country in the world calls it a first-inventor-to-file. They call it a first-to-file system. So the fact that they have chosen an unusual, confusing title for a provision that's supposed to harmonize and not cause confusion with other patent systems is the key to understanding that there is a fundamental constitutional defect with this legislation, this proposed legislation. And that's what I'm here to speak to you today about. And in fact, the Supreme Court yesterday, as Kevin just indicated, revealed this constitutional defect, even though it was deciding a case that dealt with one of those very confusing, eye-glazing intricacies of patent law. The case was Stanford v. Roche Molecular Systems, and it was a question about the statutory interplay between what's known as the Bayh-Dole Act and the Patent Act. I'm not going to get into the details of this case, it's not necessary, but what is important is that the court had to go back to and identify the presumptive foundation of our patent system, which is the first inventor receives the property right. In fact, the very first sentence of Chief Justice Roberts' opinion for a seven-justice majority states, since 1790, the patent law has operated on the premise that rights in an invention belong to the inventor. And then he later states in Section 2 of his opinion, although much in intellectual property law has changed in the 220 years since the first Patent Act, the basic idea that inventors have the right to patent their inventions has not. Now, this is very, very important because the defenders of the H.R. 1249, specifically Section 2, such as the 21st Century Coalition for Patent Reform, have been propagating lack of a better term, open untruths about the history of the patent system. They've actually been proclaiming that the United States had a first-to-file system from 1790 to 1836 without any, of course, citations to any of the relevant statutory language or any court opinions or anything. This is just a bald assertion. And they constantly refer to the constitutional clause that powers and Congress to enact patent laws, but all they talk about is one portion of this clause. They constantly talk about the fact that this provision will promote the progress of the useful arts, quoting the language from the constitutional provision. Well, let me read to you the entirety of the constitutional provision that is actually provided in Chief Justice's opinion from yesterday, Chief Justice Roberts' opinion from yesterday. Congress has the authority to, quote, promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries, end quote. And of course here, the operative language that is selectively redacted from its repeated white papers is inventors and discoveries, which is a limit, an express constitutional limitation on Congress's power to promote the progress of the useful arts. And this is why for 220 years, from the very first Patent Act of 1790 all the way up through today, the U.S. has had a unique patent system relative to the rest of the world. It is secured to first inventors their property rights and their discoveries, their inventions. Now, why did it do so? Well, because the Americans understood that they were doing something different in their patent system from England and many other countries. At the time, in the 17th and 18th century, England and other countries viewed patents not as property rights, but as personal privileges granted to inventors by the state for whatever economic or regulatory purpose it was trying to obtain. Thus, they weren't property rights, they were personal privileges. The United States broke with this. Unsurprisingly, we had a revolution that broke from England, and as part of our American exceptionalism, we not just broke in fundamental conceptions of the rights of property and liberty, but we also broke with respect to the traditions to securing to inventors their property rights and their inventions. And this is why in the Constitution it refers to inventors and discoveries, and this is why for 220 years Congress has implemented this language securing to first inventors. And this is not an inference from the historical record. As Chief Justice John Marshall recognized in a court decision in 1813, the quote, Constitution and law, so Constitution and law, taken together give to the inventor from the moment of invention an inchoate property therein, which is completed by suing out a patent, end quote. Thus, the American founders and the follow-on justices and legislatures who implemented and created the very first patent rules in this country understood that they were doing something different from the rest of the world. They were securing to inventors their justly earned property rights, and thus set up a set of institutions and legal rules formulated around securing the right to property. And thus, unsurprisingly, what one finds in the historical record is many references to the fact that patents, although statutory rights secured under the express provision of the Constitution, are nonetheless justified by natural rights philosophy, invoking the classic natural rights claim that property rights such as patents should secure the fruits of one's labors, or in the patent context, the fruits of one's intellectual labors. Thus, the very famous antebellum Congressman Daniel Webster declared in 1824 on the House of the Floor of Representatives, the very institution that will be potentially voting on 1249 next week. This is what he informed his fellow congressmen back in 1824. Quote, "The right of the inventor is a high property. It is the fruit of his mind. It belongs to him more than any other property, and he ought to be protected in the enjoyment of it," end quote. And this wasn't unusual. In 1845, Supreme Court Justice Levi Woodbury was instructing a jury in a patent case that, quote, "We protect intellectual property, the labors of the mind, productions and interests that are as much a man's own, as much of the fruit of his honest industry, as the wheat he cultivates or the flock he rears." And they, in fact, believed in this. This wasn't empty rhetoric. As a result of this belief, American justices like Chief Justice Marshall, Justice Story, Justice Woodbury, and legislators implemented in the patent system the exact same rules that had long secured property rights and land in the patent system. And this was a unique to America. No other country was doing this. They secured to inventors their rights to commercialize their property rights and their inventions, importing into patent law the same legal rules that had long secured the rights of property owners in land. They provided constitutional protection under the Takings Clause, which you'll hear from my colleague Jonathan Massey about. They provided constitutional protection to patents under the Takings Clause of the Constitution, again recognizing that patents were property rights on par with property rights in land. And they adopted many other legal doctrines and rules from property, citing to real property cases as determinative precedent for deciding patent cases. Now, why am I going on and on about this? Well, because it has become necessary, because as I said, there has been the spreading of substantial half-truths and misrepresentations about the Constitution and about the historical record of the development of patent law. The 21st Century Coalition for Patent Reform, as I said, has been emphasizing that the progress provision is what empowers Congress to adopt a first-to-file system. That is incorrect. It's because what empowers Congress to adopt a patent system is its injunction that is secure to inventors their exclusive right in their discoveries. Now, that's for the purpose of securing the progress of useful arts, but that is not an open-ended grant of authority to Congress to do whatever it wishes, including harmonizing with other countries. Moreover, as I said, that they've been spreading the untruth that there actually has been a first-to-file system from 1790 to 1836. And they haven't cited a single primary historical source for this that is relevant. None of the language from the early patent acts, because they can't, because the patent acts speak in terms of securing to the first and original inventor. Moreover, the historian that they cite to, Edward Waltersheed, I brought his primary text with me. I specialize in patent law history. I study this. You can see all my little tabs, right? Walter Shea does not say that we had a first-to-file system from 1790 to 1836. I won't bore you with the details in here. It gets a lot into this kind of historical nitty-gritty issues, but the fact of the matter is that there has been misrepresentations and out-of-context quotes that are constantly being made about the historical foundations of this, the patent system in this country. So to sum up, the whole basis of our patent system in this country, the whole idea of protecting property rights and inventions, securing to inventors the fruits of their intellectual labors, cannot and would not have made any sense but for the fact that Congress recognized that it was securing the right to property and invention to the first inventor, in the same sense that the first possessor of land gets the property right to that land. The whole structure of our patent system would collapse if you reject this foundational premise that is rooted not only in repeated historical decisions by the Supreme Court, in congressional statements, in the statutes, but as well in the Constitution. And thus, H.R. 1249 must be rejected, if only for the reason that Section 2 is blatantly unconstitutional and violates its tradition. But you will hear also from my fellow panelists all the other reasons as well why it should be rejected. So thank you.